price per cubic foot in commercial, not in residential. So you asked that question and then you answered it yourself. So that means you're learning, it means you're getting there. So good job. All right, in New Jersey, a contract is defined as a voluntary agreement between two or more competent parties supported by consideration, where the parties agree to do or refrain from doing some legal act. Competent parties means 18 sane and sober. 18 sane and sober. Supported by consideration means something of value has to change hands. And in a real estate contract, which changes hands of value, is the purchase price for the house. By the way, a voluntary agreement between two or more competent parties supported by consideration, wherein the parties agree to do or refrain from doing some legal act. Refraining from doing an act is called a forbearance. Refraining from doing an act is called forbearance. If I was to sign a contract to sell my school, the buyer would make me sign a contract that said I would not open a school in the state of New Jersey, because otherwise I could compete with them. That would be a forbearance. Okay? And when you sign a contract, it has to be for some legal act, because the thing that I think the government does best, whether it's the federal government, the state government, the local government, the thing that they do best is to deal with contracts and to help you make sure that both parties do what they promised to do in a contract. Because you can, as the most severe remedy for breach of contract, sue the other side for specific performance. But we'll get to that in a minute. In New Jersey, the Statute of Frauds. In New Jersey, the Statute of Frauds governs real estate contracts. And again, we have to be sane, sober, 18 or over, no duress, reality of consent. That's the definition of a competent party. Consideration is something of value that changes hands. It's the money for the house, or it could be you're exchanging your car for another car. Again, that's consideration. It's something of value. Has to be a legal act. And again, I bring up marijuana because marijuana is illegal on a federal level, but it's legal in, I think, 9 states now for recreational use. The 9 states where it's legal, you cannot use a credit card or a check to buy it, because credit cards and checks are in fact contracts. And on a federal level, they would not be valid because you cannot have a contract for an illegal act. And on a federal level, marijuana for recreational use is illegal. So again, you have to have a legal act. Why? Because the courts, in some cases, have to get involved in enforcing a contract. Again, the Statute of Frauds governs real estate contracts. It was amended in 1996, where it says that real estate agreements can be oral in nature. Real estate contracts can be informal, real estate contracts can be oral if there is a predominant of clear and convincing evidence. If there's a predominancy of clear and convincing evidence. I have a chat here, let me see what it was. Doesn't the Farm Bill change that in some way? Well, it might, but it hasn't yet. That's a good question. It might, but it hasn't yet. You know, if we had Bernie Sanders running for president, we would have heard a lot about marijuana in the campaign. But our 2 candidates now, both of them are not going to touch it with the 10-foot pole. All right, there's another law called the Statute of Limitations. The Statute of Limitations governs how long we have to enforce a contract. And for real estate, the Statute of Limitations says we have 2 years to enforce the real estate contract. On other type contracts, you have 6 years in order to sue for breach of contract. In the Uniform Commercial Code deals with how contracts are written for other types of commercial activities, like leases on your cell phone, or like a contract to do repairs on your house, okay? But the Statute of Frauds is the one that does real estate. So can you give an example where it would actually take that long? You have a deal with somebody to sell a house, and you keep hoping and hoping and hoping. I have a really good example now. I have a house that's in South River, has an oil tank leak. We've been trying to get a no further action letter from the state of New Jersey for 2 years. So we cannot transfer ownership of that house until we get a no further action letter. And so if we end up getting a no further action letter, but now the buyer has bought something else, and he can't really buy this house until he gets rid of or gets more money to buy this, well, if he doesn't do it within 2 years, then we could sue him for breach of contract. Again, you know, every circumstance has the potential for being something that could be a lawsuit. Now, I've had people who I've had the opportunity to sue, and just because it got too busy, I didn't sue them within 6 years, and now I can never sue them. A letter of no further action, somebody's asking that. A letter of no further actions happens when you have a leaky oil tank that's under 2,000 gallons. As soon as the municipality sees it's a leak, the state of New Jersey is notified, and it creates an automatic lien pending the cleanup. So you've got a leaky oil tank in your side yard. The municipality sees it when they come out to inspect removing the oil tank. They notify the EPA. Now there's a lien against your house until that remediation is finished. So you come out and you have the remediation done. Then you have to hire a geologist to come out, and the geologist comes out and looks around and shakes his head up and down and says, yeah, that looks good to me. And he issues you a letter of no further action. That letter of no further action then is sent to Trenton, and Trenton removes the lien for the cleanup because the geologist said there's no more need for a cleanup. So that's a letter of no further action. Okay. Now we're going to talk about types of contracts. And this is a whole bunch of different concepts and different directions, so we kind of have to go through each one. First thing is unilateral or bilateral. Remember, uni means one, bi means two. So a unilateral contract, only one party has to perform. In a bilateral contract, both parties are responsible for what they agreed to, and they have responsibility of performance. We'll define each of these as we go further into the slides, but we have valid, void, or voidable, enforceable or unenforceable, executed or executory, express or implied, all different types of contracts. So the first one is unilateral or bilateral. Unilateral means one. Uni means one. Only one party can be forced to comply. The other party performs at their option. And that's why we call it an option contract. That's why it's called an option contract. So the buyer and the seller agree that the seller is maybe going to sell the buyer a house. Maybe going to sell the buyer a house. So I'm going to answer a question here. Is it a potential thing to consider in real estate, or is it common to always follow through if you have a valid suit? Sometimes you don't follow through if you have a valid suit, because when you sue somebody for specific performance, because the buyer potentially didn't show up at closing, and you sue, that ties up you being able to sell the house to someone else for a period of time until you get into court. And you might take 2 or 3 years to get into Superior Court in New Jersey. You don't necessarily get in there very fast. So sometimes the better business decision is just to forget about it and not sue. And remember, just saying I'm going to forget about it, that's called a rescission. And we'll get to that later on in this chapter in these slides. So the factors that when you sue or not sue are not about your reputation. We're not suing about reputation in real estate. We're suing about whether you did what you're supposed to do in selling the house. All right, so let's go back to an option contract. A seller and a buyer come to an agreement on an option contract. There are 3 essential elements on an option contract. You have to have a named price. You have to have a named price. The buyer has to give the seller some money for keeping the offer open. That's called option consideration, and there's got to be a time period. So in order to have a valid option, you have to have a named price. We're going to sell the house for $300,000. Maybe the buyer gives him some money called option consideration. Here's $1,000. And now you're going to give me a year to make up my mind if I want to buy it. Anytime during that year the buyer decides he wants to buy, the seller has to sell. The seller can't sell to anybody else during that year. At any time during the year the buyer decides he wants to buy, the seller has to sell him the house, and they sell it on that agreed price. If the year ends and the buyer has not executed his option, then the option is no longer in effect, and the seller is free to sell it to anyone he wants. So again, in today's market, where prices are going up very fast, sellers would never agree to this. Because why would a seller say, I'll give you a year to make up your mind? Because in a year, prices might be 10, 15% higher. In a down market, though, sellers would be much more negotiable to sign an option contract. So an option contract gives the buyer the right to buy it for a set price within a certain time frame. He pays option consideration for it. If the buyer does not exercise his option, the seller keeps that option consideration. What do you need to have an option? Agreed price. You have to have a time frame, the option period, and there has to be option consideration. Wholesalers and flippers use this all the time. And wholesalers and flippers, you know, they're not really working in the best interest of sellers. Most of the time, they're looking to make the option consideration $1. And that's hardly fair to a seller to make the option consideration $1, but many times that's what wholesalers are taught to do. And sellers only do that because they're uninformed. You know, you've got to remember that sellers, and when they're dealing with wholesalers, wholesalers are under no fiduciary obligation. A real estate agent is under a fiduciary obligation. So is there a maximum time that an option can be? No, it can be any amount of time you agree to. Another person asked, I have a seller where the tank sweep was done and shows possibly oil tanks. I gave him a licensed oil tank company to do the sweep with ground penetration radar. He insists on removing it himself. Well, he can remove it himself if he files a permit with his town, and the town is going to go out and do an inspection before they'll allow him to take it away. We looked at those pictures last week where we had an oil tank taken out in New Brunswick, and they just sit on the side of the driveway till the town comes and looks at it. And if he does have contamination, then he is going to have to open a DPA file. Now, if he takes it out himself and just gets rid of it, well, he is not acting in a manner where he could sign an affidavit that says he's not aware of any oil tanks being removed. Right? There's nothing illegal specifically about removing an oil tank, but because it's on your own property, except you're doing it without a permit, which again is a violation. And if you remove it yourself, you can't honestly say that you didn't remove any oil tanks. And in attorney review, the attorneys ask that you sign an affidavit that says you've never taken out any oil tanks or you have no knowledge of any oil tanks. So again, you know, the situation that you're speaking of there, you know, is an opportunity for a seller to get sued, right? Because he's going to sneak out an oil tank. So I don't recommend that. All right. How does the buyer make sure that if you have an option deal, how does the buyer make sure that if you have an option deal, that the seller won't get sneaky and try to sell the house to somebody else during the option period? Well, the way you would make sure that that doesn't happen, the way you would make sure that during the option period, the seller wouldn't get sneaky and try to sell to somebody else, is you would record the option. So you would record the option, and that would keep the seller from being sneaky and trying to sell it to someone else. Now, how would that stop him? Because if you recorded the option, when the title company for the third person, the buyer, not you, but the other buyer, did their title search, the title search would find the recorded option and then wouldn't issue title insurance. And again, if the seller did sell it to a third party during your option period, you would actually have the opportunity then to sue and say that he should have sold it to you. Now, this brings us back for just a second to deeds. Because remember on deeds, when you make those covenants or promises, one of the promises on a deed is the covenant of quiet enjoyment. That's when you're promising that nobody with a superior claim will come up and say they should be the owner of the property. So if you were a seller and you were a crook and you had an option contract and I had the option, I was the optionee, and you decided to sell that to another party and he didn't get title insurance, he went ahead and closed, I would go to the courts and say, no, that property should belong to me because I have an option and I'm exercising my option. And what would happen would be the courts might return that because the seller in the deed would have had to make a covenant of quiet enjoyment, and he has violated his covenant of quiet enjoyment. So again, this is where this stuff all connects to other chapters. This is where it starts to get really in your brains. It gets really cool because it starts to all connect to other chapters. All right, the next kind of a contract is a bilateral contract. You have a buyer and a seller. Both parties have the responsibility of doing what they promised, and they both have the expectation of receiving what they expected. And both parties have the right to sue the other if the other doesn't do what they said. And that brings us back to an option for a minute. The seller in an option contract does not have the right to sue the buyer to force him to buy. The seller cannot force the buyer to buy. However, in a bilateral contract, the seller can force the buyer to buy. And we'll get to that remedy later on when we start talking about the remedies for breach. The next kind of a contract we want to talk about is a valid contract. A valid contract is one that has all the essential elements that would allow a judge in a court to force enforcement of the contract. Because if you didn't have all the essential elements, like you were signing a contract for an illegal act, you couldn't go to the court and say, force him to do an illegal act. So a valid contract is one that has all the elements that make it a valid contract, and it would allow a judge to enforce the contract. And again, it's one of the things that I think government does best, is enforcing contracts. A void contract is one that is lacking one of the essential elements of a contract. And quite often we talk about in void contracts a dual contract, D-U-A-L. And no, it's not about shooting people. It's not about Alexander Hamilton having an honor duel. A dual contract is a very specific type of way of defrauding a bank. A dual contract is a very specific way of defrauding a bank. And here's how it works. In a dual contract, you have a $100,000 house and you're selling it, and you have a buyer who has no money. So the buyer says to you, I want to buy that house for $100,000 and I have no money. I got $0. So let's do this. Let's go to the bank and let's tell the bank that the sales price is $120,000, not $100. And we're going to tell the bank that the buyer who has no money, I gave you $20,000 as a down payment. And now the bank will lend me $100,000. Now, why this is illegal is because you are defrauding the bank about the true loan to value ratio. You're defrauding the bank about the true loan to value ratio. And that kind of a contract is called a dual contract. That's a contract where you have one contract for the bank, and it's different from the real contract you have with the seller. That's the most common type of a void contract. Of course, if you signed a contract for buying 1,000 pounds of marijuana, that would be a void contract because it lacks the essential element of being for a legal act. Okay, and again, this is the example. $100,000, he has no money, he's going to purchase it, he's going to tell the bank it's $120, he's going to tell the bank he gave the seller a $20,000 down payment, the buyer gets a $100,000 loan, he gives it to the seller, he really only paid $100,000 for the seller, but the lender is misled about the true loan to value ratio. That's what a dual contract is. Another contract is a contract that is voidable. Avoidable is where one of the parties can raise their hand and say, listen, pal, we don't have a contract. So my example is, my nephew was told by his mother he could buy a car if he got a good report card. He went out and he negotiated the deal to buy a car, but when he was negotiating, he asked the seller to put new tires on it. The seller put new tires on the car and brought it over to my nephew's house. But at the same time, his report card came and he got a terrible report card. So his mother came out and the guy was there to deliver the car. He says, my son's not buying any stinking car because his report card was bad. And so in the end, the adult who was selling her 17-year-old son a car, my nephew was 17, selling a 17-year-old a car. His mother could come out and say, he's not a competent party, therefore he can void the contract. So it's a voidable contract. And that means the adult who was selling the car can't sue the kid for not buying it. It's a voidable contract. Now, the reason it's called voidable is because it's really only voidable by the 17-year-old. If the adult came up and with the car seller came up and said, I want to void the contract, the 17-year-old could force him to perform because the adult was a competent party. So only the 17-year-old is in the position to void the contract. Okay? So a voidable contract is a contract that one party could potentially void because of some reason that makes it not a legal contract, or it doesn't have all the essential elements of a contract. Another thing we have to consider is enforceable or unenforceable. So if we go back to avoidable contract, we can see that if we have a senior, you know, a 25-year-old guy who's selling his car to the kid, he can't make the kid buy the car. It's not enforceable against the kid. But the kid could make the senior sell him the car. So it is enforceable against the senior. So it's unenforceable against the kid because he's not a competent party, but it is enforceable against the senior. All right, so that's enforceable versus unenforceable. We have a lot of that in real estate, a lot of enforceable versus unenforceable contracts. Let's see, we got a question here. In a bilateral, both parties promise and are obligated to uphold certain actions to another party, or party is responsible for the person or party's action. Okay, that's a nice legal definition. So that's a nice legal definition, but I'm not going to read that because my wife is nearby and she's a lawyer. She doesn't like me playing like I'm a lawyer. She'll come over here and smack me. All right, so enforceable or unenforceable, will the judge, if he was asked or she was asked, would she enforce the contract, or would she say it's unenforceable against my 17-year-old nephew? Now, the next thing is executed or executory. We have an executory contract when we first make a deal, when we first have a meeting of the minds, when we first have an offer and acceptance. We have an executory contract. And what happens in real estate, in an executory contract, you have your bundle of rights. And one of the things in your bundle of rights is this very important one here, which is the right to sell or not sell. Sell or not sell. So when you sign a contract, when you come to an agreement with a buyer, that one right comes out of your bundle of rights and it goes into the buyer's hand. The buyer then has that right. So the buyer actually has what is called an equitable ownership interest. He has an executory equitable ownership interest. He actually kind of owns the property at the moment there's an agreement. An executed contract is when both parties have finally done everything they promised. An executed contract is when both parties have finally done everything they promised. So that's important on a lot of bases, but it's important on our commission. Because technically, when you have a deal, when a buyer and seller both sign the contracts and you have a deal, now we're going to forget about attorney review because that's just the complication, but in terms of just the explanation of how this works, when a buyer and seller both sign and you have a deal, you have an executory contract. We have, as real estate agents, earned our commission then. However, we don't get paid our commission until there's an executed contract, until it closes. Executed contract. We don't get paid our commission until there's an executed contract. Why does this matter to you? Because before you can begin work with your broker, you have to sign an employment agreement. And one of the essential elements of an employment agreement is a termination agreement. And what a termination agreement deals with is what happens if you quit here. You've earned your commission here, but you quit here. How much are you going to get paid? Sometimes you'll get 100%. In my office, you'll get all your money. If you're in Weichert, you're going to get 50%, right? And every office is different, and every office signs you up depending on what they want to make their employment agreement. I can't say one is better than the other. I can tell you the reasons people do what they do and the motivation, but when you go to interview for your position of being a salesperson, it's one of the questions you're going to answer. Let me see the termination agreement. What's going to happen if I leave you after something's under contract, but before it closes? So again, we earn our commission when we have an agreement. We get paid when it closes. We get paid at closing. Therefore, we need a termination agreement in our employment agreement. So these are the essential elements in the employment agreement. Doesn't necessarily belong in this chapter, but it is a contract. Your essential elements in your employment agreement with your broker are the commission you're going to get paid, what's your split going to be, a promise by the broker to pay you within 10 days, the termination agreement that we just talked about, and a statement that says in your agreement that all things that are in writing take priority over oral items, because many times there's misunderstandings about oral things. So again, whatever it says in your contract is what takes priority. Then we have express or implied contracts. So in the old days, you used to pull into a gas station and you'd say, fill her up. It was implied that when they filled you up, you would pay them. Now it's the opposite. Now you give them your credit card and it charges you as the gas goes in. But still, when you go into a restaurant, as long as restaurants are open, it is implied that if you order food and eat it, you're going to pay. That's an implied contract. Payment is implied. An express contract is when you have a written contract and everything that both sides agrees to is written down. So a typical contract for the sale of real estate, a typical contract, is an express bilateral agreement. A typical real estate contract is an express bilateral agreement. An option contract is an express unilateral agreement. A listing agreement is an express bilateral agreement that is contingent usually. Contingent means you don't get paid unless the people get their house sold. So in order to have a contract, we have to have an agreement. And we call an agreement an offer and acceptance. We call an agreement a meeting of the minds. Any of those terms means that the buyer and the seller have agreed on all the terms. The buyer and the seller has agreed on all the terms. So in real estate, who normally makes the offer? And the person who makes the offer is called the offeror. Offeror is the one who makes the offer. Typically, in a real estate transaction, it is the buyer who makes the offer. The buyer makes the offer and it goes to the seller. Now, when the buyer makes that offer and it goes to the seller, a number of things can happen. The seller can accept it. That means they say yes. The seller can reject it. That means they say no. Or the seller can say no, but. And so again, we're going to say the buyer is going to make an offer for $100,000 and the seller is going to say no, but I'll take 105. So originally the buyer was the offeror and the seller was the offeree. When the seller says no, but I'll take 105, now the seller becomes the offeror and the buyer becomes the offeree. And this can go back and forth 10, 15 times. I'm negotiating on one of my listings that's priced at $750, and we're going back and forth at $1,000 a clip on a $750,000 house. When you're arguing about a couple $1,000s, it drives me crazy. So it can go back and forth a couple times. Now let's look at another scenario. Another scenario is that the buyer is going to make an offer. So he is the offeror. Buyer makes that offer. The seller is the offeree. Certain things can happen. The buyer gets tired of waiting for the seller to answer. He can withdraw his offer anytime prior to acceptance. The buyer also could put a time limit. This offer is good for 24 hours. What else could happen? The house could burn down. Destruction of the premises terminates the offer. What else could happen is the house could get foreclosed. Act of the courts terminates the offer. So those are all things that can terminate an offer. Also, keep in mind that acceptance terminates an offer. Because if the seller at some point says yes, then the offer now becomes a contract. Okay? Now, this is all important in other states, much more than in New Jersey, because in New Jersey, we have attorney review. And in an attorney review, if you get an offer accepted, your attorney can kill it for any reason. In other states, if an offer gets accepted, you're stuck with that offer. but we have attorney review in New Jersey, so it makes it a little less stressful to accept offers or to shoot offers back and forth. So in an original offer, the buyer is the offeror and the seller is the offeree in the original offer. The offer may be terminated by a lapse of time. You have 24 hours to make a decision. It can be withdrawn anytime prior to acceptance. I'm the buyer. I made an offer on your house. You've waited too long. I'm withdrawing my offer. The offer can be rejected by the seller. The offer can be accepted by the seller, which now makes it a contract. The offer can be countered by the seller. Remember, a countering is a rejection and a change of roles, because that would be where the seller would reject your original offer and make you a counter offer, and now the seller would be the offeror and the buyer would be the offeree. An offer can also be terminated by the death or the insanity of the offeror or offeree prior to acceptance. It can be terminated by the destruction of the premises, and it can be terminated by a change in the law that makes the object of the offer illegal. All of those things can terminate an offer. And we got a question here. Let me pull up the question. So most contracts do have a force majeure in it, and not so often in real estate contracts, but you're going to see a lot of force majeures in contracts over COVID, because if you have a force majeure paragraph in a lease, is the government shutting down your business, your health club, by not allowing you to open, is that something that can be brought under force majeure? But we're not going to talk about that because that's very seldom used in real estate. So we're not going to talk about that. What if you have an offer accepted and a better offer comes in before it goes through attorney review? So if and this happens every minute in today's market. You accept an offer, it goes into attorney review has not been completed yet. A higher offer comes in. In attorney review, the attorney can cancel the contract for any reason. Don't even have to give a reason. They can cancel it for any reason. So you could terminate the first contract and accept the second contract. And that happens every day now. Can I go over offeror and offeree? Yes, the person who makes the offer is the offeror. In a real estate contract, typically it's the buyer, and he gives that offer to the seller. The seller is the offeree. If the seller counter offers, if the seller says, no, I won't take 100. Oops. Sorry about that. If the seller says, no, I won't take 100, but I will take 105, now the seller is the offeror and the buyer is the offeree. They've just changed their position. It's like a game of tennis. The ball can go back and forth and be in the other person's court. And when you finally have an agreement, the agreement becomes a contract. All right, I hope that helped enough. Now, assignment of a contract, we talked about a minute ago, we talked about it with options. What an assignment of a contract is, remember your bundle of rights, when the buyer and the seller sign a contract, that right for the buyer to buy the house, right, goes into his hands. It's an equitable ownership interest. Now, what if that buyer wants to sell that equitable ownership interest to this guy over here? Well, an assignment allows him to sell that right to him. And again, let's say originally you agreed to pay $100,000 for the house, and now you've got a contract, so you've got the right here, and now you're going to assign it to this guy for $105,000. That means this guy here would pay you $5,000, and now he would have the right, and he would pay the seller $100,000. So that's an assignment of a contract. So the property I'm talking about in Edison, I'm looking to do the same thing. The property I'm talking about in Edison, I am looking to buy it for $220,000, get a contract for $220,000 out of the seller's bundle of rights. The right to sell or not to sell is going to come to me. This is me here with a happy face. If he does that, I have that right. I can force him to sell it to me now. And I'm hoping to be able to assign that contract to a third party. So if I can find a third party that will pay me $250,000 for it, then I will assign the contract to the third party for $250,000. He'll have that right. He'll give me $50,000. And when we close, the original seller will still get his $200,000. this is the way you wholesale. And I've done this a couple of times in my career. The guys who wholesale it do it every day. Okay. What's the risk here? What's the risk? Here's the original seller. Here's the bundle of rights. Here's me with a smile on my face. And I'm going to sign a contract for $200,000 here with him. That equitable ownership interest comes into my little grubby little hands here. And now I want to assign the contract to this guy down here for $250,000. The risk is he doesn't perform. The risk is the market drops real fast all of a sudden. And now I am still obligated to buy the property for $200,000. That's the risk. Now think about it. How could I get rid of that risk? How could I be rid of that risk? So in case the market dropped, I wouldn't have to buy it. Instead of signing a contract with him so I'd be able to assign it, instead I would look for the seller to give me an option contract. And that would mean if I couldn't find somebody to sell it to, I wouldn't have to buy it because it's an option contract and I only have to buy it if I, as the buyer, decide to buy it. Okay, so wholesalers use both assignments of contracts and options of contracts. And this assignment of a contract is so valuable and this assignment of contract so favors the buyer that in a normal real estate contract, it says in a normal real estate contract that we are allowed to use, one of the paragraphs states no assignment without written permission of the seller. And that's why this one that I'm trying to do the deal on, I would list the seller as Bruce Parker and or assigns, because saying and or assigns gives me permission to assign the contract. All right, who goes to closing? Well, I want to tell you, all of you should go because you want to make sure you get your check. Everybody's always looking to cheat you. And sometimes, you know, the seller who originally got under contract with you might say, well, gee whiz, how come you made $50,000 and didn't do anything? Well, that's the risk he took and the risk you took. Can the seller disagree to sign the contract which has an assignment included? Of course. And in the normal real estate contract that we're allowed to use, there's a paragraph that says no assignment without written permission. But once the seller gives you written permission, it becomes an essential element of the contract. In an option contract, if you don't exercise your option, we don't want to call it deposit in an option contract. We want to call it consideration. In an option contract, if you do not exercise your option, you lose your option consideration. But think about it a second. Remember, I told you the flippers make their option consideration $1. So they don't care if they lose $1. That's not a really good deal for a seller, but that's the way flippers do it. Flippers offer $1 as option consideration. Okay, you know, I've made $100,000 assigning a contract in the past, and I've made more often than that. I've made $10,000 or $12,000, not a big number. But again, it's a way that you could actually make money without having any money, because if you could negotiate really good contracts and assign them all the time, you don't ever have to have a penny. You're taking a risk that if the person that you assign the contract to can't perform, you'll be stuck for performance. But, you know, that's a risk. It's a business decision whether you want to take it or not. It's not a legal decision. It's a business decision. That's an assignment of a contract. So this has got to settle in your brain for a little while, maybe Google a little bit about it tonight and look around. But this is the way wholesalers and flippers really make their money. The guys who buy stuff and fix it up and resell it, you know, they've got a year tied up in fixing it up. They've got all kinds of costs in terms of the repairs. The guy who is just assigning contracts doesn't get his hands dirty ever. All right, again, if you assign a contract, one of the big questions is who is liable for non-performance. If the end person who bought the assigned contract from me doesn't perform, am I liable to be sued for non-performance? Statute of Limitations is 6 years to sue. 2 years is the statute of limitations for performance on a real estate contract, the limit. The parole evidence rule states that anything that's in writing takes priority over anything that's oral. And the parole evidence rule says that any changes to a contract must be initial. parole evidence rule says any changes to a contract must be initial. So you're writing a contract up and you offer $100,000 on the contract, and the seller says, no, I won't take 100, but I will take 105. Typically what you do is on the contract, you cross out the 100, you write the 105 in, you write a little box or circle like this, and you ask the seller to initial here and initial here, the seller and his wife, and the buyer and his wife initial here and here. So all the changes have to be initial. That's the parole evidence rule. Of course, you could write up a whole new contract if you want, but I really think making the changes and let everybody see it actually kind of validates your worth, because it kind of shows it what you've been doing. The seller will understand that you got him an extra $1,000, $5,000. Well, I'm glad you like them. If you sign a contract, give a deposit before closing, the buyer loses his job, so he cannot get the loan. What happens in that situation? We'll get to that in a few minutes. That's a good question. All right, the next thing we want to talk about is that the IRS wants to know who's laundering money. And how does the IRS know who's laundering money? Anytime you have a transaction with over $10,000 in $100 bills or in $20 bills, somebody has to report it to the IRS. Now, you can put the money in your bank account and write a check for $10,000. That doesn't matter. But if you bring $10,000 to closing or more, then they have to report you to the IRS. It's not illegal to bring that money, but then the IRS investigates you to see if you're a money launderer. A couple of the words you're going to have to know. And these are like those questions you have on the SATs where they say this is to that as this is to that. And my son just took the SAT today. So these are the kind of questions that you see a lot. So vendor, that's the person who is selling a house, seller. A vendee is a buyer. So quite often on the test, you'll see vendor is to seller as grantor is to what? And the answer is the grantor is the seller, right? You might see, vendee is the buyer, is grantee is to what? And grantee is the buyer. Grantee is the one who is getting the deed. Okay, vendor is a seller, vendee is the buyer. Grantor is the seller, grantee is the buyer. Mortgagee, the one who gets the mortgage, is the lender. Mortgagee, the one who gets the mortgage, is the lender. Mortgagor, the one who gives the mortgage, is the borrower buyer. So the buyer is the mortgagor. So in real life, when you're talking to your friends and they say, I'm going to go get a mortgage to buy a house, you'll say, I'll bet you're not going to get a mortgage to buy a house. I'll bet you, the next round of drinks. And the answer is he is not going to get a mortgage to buy a house. What he's going to do is he is going to give a mortgage to the bank and give a promissory note to the bank in order for the bank to lend him money. So when you buy a house, you're giving a mortgage. The buyer is giving the mortgage. That's why the OR is on the end, because the buyer is giving the mortgage. The buyer is the mortgagor. The buyer is mortgagor. That's why the OR is on the end. OR means giving. Just like OR on the end of grantor means the seller is giving the deed. Okay. A little bit confusing, but you got to get it. Earnest money. Now, we said a contract, one of the essential elements is it has to be supported by consideration. Consideration means the sales price for the house. Sometimes real estate agents will tell you you have to give a deposit in order to make an offer. That is nonsense. The reason they tell you that is they think the deposit is the consideration, because you have to have consideration with an offer. The earnest money is not consideration. The earnest money is merely an indication of how earnest you are in the deal. Sometimes it's called a good faith deposit. You're indicating your good faith in the deal. It's not part of the consideration. The purchase price is the consideration on one side. The house is the consideration on the other side. Okay, now we're going to talk about breach of contract. What happens when one party doesn't do what they promised to do? And that's called default. When one party doesn't do what they promised to do, that's called default. So we can have a breach by the seller. And guess what? We will have breaches by the seller this fall. Why? Because the seller will get under contract for an offer, and all of a sudden an offer for $50,000 more will come in. I've seen this already. $50,000 more will come in. The seller will try to breach. You know, if you're already through attorney review, and so now you've got a valid contract, the seller is not allowed to breach, is not allowed to get out of the contract. If he just doesn't show up at closing, if he just doesn't show up, that's a breach. And if he breaches, what are the remedies for the buyer? What are the buyer's remedies for the breach? And you will see breaches this fall where sellers just don't show up at closing because they got a higher offer from someone else and they're considering taking it. See what the question is here? Is earnest money the same as earnest money? Yeah. Either way you spell it, it's the same thing. Unless your name is Ernest, and then it's Ernest's money. So breach by the seller, what are the buyer's remedies? The first remedy is rescission. And I like to tell the story about Winston Churchill. Winston Churchill came to New York after World War II, and the creation of the United Nations was going on. And he was at the United Nations, and he stepped out onto the streets, and he looked the wrong direction. Because in England, you look the opposite direction when you step onto a street. You don't even think about that here, because when you step out onto the street, you always look to your right. But in England, when you step out onto a street, you look to your left. So he looked to his left, a car was coming from the right, and it ran him over. So Winston Churchill got up and he said, forget about it. Don't worry about it. Well, it turns out he had internal injuries. When he finally got back to London, he suffered from those internal injuries and his health was never the same. But when Winston Churchill got up and said, forget about it, that's rescission. Rescission says you're going to return to the status quo. You're going to pretend like it never happened. So if the seller doesn't show up at closing and the buyer's sitting there at the closing table with all his money, the buyer could just get up and say, forget about it. But if he does that, if he does rescission, he gets no damages. So rescission is the least desirable option. If you're riding a bike and you get hit by a car, the least desirable option is say, let's pretend it never happened because you don't get any damages. So rescission is the least desirable option. The next option that's available is to sue for compensatory damages. The seller doesn't show up at closing. The buyer has moved out of his home. He's hired a moving van. He's applied for his mortgage. He paid for his appraisal, paid for his title insurance and his survey. Well, he could sue for all that money he spent. He could sue. He could also sue if the price went up from the time they signed the contract. Let's say they signed a contract back in April. Prices are probably up 10% from then now. So if the seller didn't show up now on a contract that was signed in April, the buyer could sue for the increase in value. Okay, another thing that's part of the compensatory damages. And if the buyer was really a litigious type person and the buyer really wanted to get the house, he would sue for specific performance. Specific performance is when you go to the judge and you show the judge what happened, and the judge can compel the seller to deliver the deed to the buyer. That's specific performance. What's the least desirable remedy? The least desirable is rescission, because you get nothing. You're just saying, forget about it. So those are the remedies that are available to the buyer if the seller breaches. We also have remedies that are available to the seller if the buyer breaches. So when do buyers breach? When prices are going down like crazy. You sign a contract in in January of 2008, and 3 months later, if prices have dropped 40%, you're not going to want to close on that house. So you just don't show up. So what are the remedies for breach by the buyer? What are the seller's remedies if the buyer breaches? Well, the first one is rescission. Just forget about it, least desirable. The next one is liquidated damages. Now, we do not automatically have liquidated damages in New Jersey. They are not normal in New Jersey. Liquidated damages are only used in New Jersey if there's a specific liquidated damages clause in the contract. And in a normal real estate contract, there is not liquidated damages. However, if you're going to buy a house from a builder, the builder, like K. Hovnanian, will typically have a 10% liquidated damages. So if you don't show up at closing, the seller gets to keep 10% of the purchase price. Okay, that's liquidated damages. In New Jersey, in order to have liquidated damages, you have to agree to it in the contract in the beginning. And we do not normally have liquidated damages in sales contracts for normal type deals. The next thing is to sue for compensatory damages. Again, this is the buyer breaching. Well, maybe the seller did repairs on the house. Maybe the seller has moved out. Maybe the price has gone down. Maybe the buyer got under contract up here at one price point, and now the price point is down here, so we had a loss in value. The seller could actually sue for the loss in value. And the very last remedy, which is the most severe, is to sue for specific performance. That's where you ask the court to force the buyer to buy. Now, the problem with suing for specific performance is, what if the buyer doesn't buy because he just doesn't have the money? It's very hard to force the buyer to pay for the house if he doesn't have any money. So we don't normally see suits for specific performance done by the seller. Typically, the seller is going to sue for compensatory damages. If it's K. Hovnanian and you don't show up, they're going to sue for liquidated damages. Now, back in 2008, I had somebody in my class who was buying a K. Hovnanian property. Oops, let's go back there. He was going to buy a K. Hovnanian property for $800,000 up at Port Imperiale in Hoboken. And when the recession hit back in 2008, when the credit markets locked up, we lost 30% of value right away. So that means that unit went down in value by $240,000. And he had a liquidated damages clause that said he would lose $80,000 if he didn't perform, if he didn't go through with it. So his choice was, did he want to lose the $80,000, just say, we're not going to do it, I'm not going to show up at closing? Or did he want to buy a unit for $800,000 that was really only worth $560,000? So again, in his choice, he decided to just eat the $80,000 worth of losses. So again, that's what this stuff is all about, because a contract is a contract, and a contract is enforceable by law. So if you don't do what you said you were going to do, you could end up in court. Now, we're going to complicate things because we have this magical thing called attorney review. So let's start off with some history. First of all, I had a closing today. My check was for $7,500. The attorney's check was for $1,000. So attorneys, they don't like the fact that we get paid 7.5 times as much as them. So back in the 1990s, attorneys wanted to make it so that real estate agents could not prepare contracts. And we don't really write contracts. We fill in the blanks on contracts. And attorneys wanted to make it so we couldn't do that. Attorneys wanted to make it so they would do all the contracts. And in states where the attorneys do prepare the contracts, instead of charging $1,000, they charge $5,000. So the attorneys and the real estate agents started suing each other. And of course, it was the Bar Association suing the realtors. And we came to a compromise in New Jersey. And the compromise was, here's the deal. We are going to allow real estate agents and brokers to fill in the blanks on contracts that are approved by the Real Estate Commission, the MLS, or the Bar Association. And we're going to allow it on 1 to 4 family homes, and we're going to allow it on condos, and we're going to allow it on co-ops, and we're going to allow it on single lots. And all those properties, the real estate agent, he can't prepare a contract, but the real estate agent can fill in the blanks on contracts that are approved by the real estate commission, the realtors, or the bar association. So the question is, could he renegotiate the same house at a lower price? Well, Canadian would rather have the $80,000. So they took the $80,000 and they still sold it at the lower price, but at least they got the $80,000. He could, of course, try to negotiate, and it never hurts to try to negotiate. But don't forget, sellers are going to do what's best for them, not what's best for you. And the more skillfully crafted the seller's contract is, the more seller is going to have power if they go to court. Okay. So let's go back to this again. In attorney review, we can fill in the blanks on 1 to 4 family homes, condos, co-ops, and single lots. And all of those types of contracts that we can fill in the blanks on have to have attorney review clauses in them. And the attorney review clause states that when both parties have signed the contract, and then those contracts are delivered to both parties, they have to be delivered to both parties, that starts attorney review. And attorney review is 3 business days, but it does not count Saturday, Sunday, or holidays. 3 business days, but it does not count Saturdays, Sundays, or holidays. And let me tell you, there's always trouble, because now that we have so many different religions and ethnic groups and nationalities around here, what constitute holidays? So again, all kinds of court cases and decisions that give precedence on this. What's the best way to understand? Don't try. Just remember for the test, it's not counting Saturdays, Sundays, or holidays. And you want to talk to the attorneys to find out if we are truly out of attorney review. If we are truly out of attorney review yet. And remember, attorney review starts when signed contracts are delivered to all parties. So in a typical contract, remember, you bring the contract to the seller, and the seller signs the contract. It hasn't been delivered to all parties yet. Only the seller has the signed contract. We still have to deliver the buyer's contract to the buyer. And there's court cases about this. What if you mail that contract to the buyer in California? When does attorney review start? Does it start when he receives that contract? Or does it start when it's postmarked? There's a thing called the Mailbox Rule. And there is precedent for saying it starts when it's postmarked. So again, attorney review is 3 business days, not counting Saturdays, Sundays, or holidays. Now, very, very misunderstood, because that's the way it's supposed to work. The way it works in real life, well, let's go one step further. What this means, if you do not have an attorney and you sign a contract, you do not have an attorney and you sign a contract, after we count off these 3 business days, you're stuck with the contract. If you do not have an attorney, after 3 days, you're stuck with the contract. Whatever it says, that's what you got to do. But during the 3 business days, you can hire an attorney and he can kill the contract for any reason. Any reason, he can kill the contract. What really happens in real life is as soon as you send those contracts to both attorneys will send out letters that say, I hereby disapprove of the contract. So on almost 100% of the contracts, the attorneys kill the contract as soon as they get it. And they say, I hereby disapprove of the contract, but I will approve of it if you make the following changes. And that's why the confusion about attorney review, sometimes attorney review lasts for a year. And it's not that it really lasts for a year. It's that originally the attorney said, I hereby disapprove of the contract, but I would approve it if you make these changes. So again, it really complicates exactly how we deal with attorney review. It really complicates it. So the best thing to do, when you get your license and you get a contract signed, you make sure it gets to both parties to be signed. You make sure it gets signed copies of it, get back to both parties. You make sure you get that stuff to the attorney, and you start talking to the attorney every minute, making sure to when they're going to finally agree. Now there's all kinds of weird rules. You could have an attorney agree that we're done with attorney review, but if it's, as long as it's within the 3 days, you can hire another attorney as long as it's within that first 3 days. That happens quite often too. You don't want to get involved in interpreting attorney review. Your job is to just know that without an attorney, once you count off those 3 days, 1, 2, 3 days, once you count that off, you have a contract that's binding. So it's always in your best interest to have your buyers and sellers hire an attorney. In real life, everybody south of Monmouth County is tempted to close without an attorney. Everybody north of Monmouth County always uses an attorney. All right, now we got some questions here. The attorney says what you just said. Does the time to get a response factor in? Sometimes it can. Sometimes it can factor in. Sometimes the attorneys will say, if I don't hear back from you by Friday, then we're going to go on and sell it to somebody else. That's quite often. Okay, so we have one more question. Let me answer that one, and we might have another one still. So somebody's saying if the attorney says that he hereby disagrees with the contract, the 3 days haven't begun yet for the attorneys, because the attorney, when he says he disapproves, it means you don't have a contract anymore. As soon as the attorney says he disapproves, you don't have a contract anymore. But he says, I will approve if you make these changes. So can they go on for a long time before they approve them? Yeah. But again, since the attorney killed the contract at first by saying, I hereby disapprove, you don't have a contract. And that means the other party can go and sign a contract with someone else. So again, it's very complicated. You don't want to get involved in counting all that stuff. What you want to do is make sure, if you get a contract, that you advise the buyer and the seller that if they don't hire an attorney within 3 business days, it's not including Saturdays, Sundays, or holidays, if they don't hire an attorney within 3 business days, at the end of the 3 business days, they have a binding contract. So that's what you want to make sure you let them know. The 3 days technically starts when the signed contracts are delivered to both parties. So again, you're a buyer. Your buyer signs the contract, and then you send it to the seller. Even if you email it, you send it to the seller. If the seller agrees, the seller signs the contract. Attorney review has not started yet, because it doesn't start because so far the only one who has a fully signed document is the seller, because the buyer's document only has the buyer's signature. When the seller signs the document and returns it back to the buyer, showing that both parties have signed it, that starts attorney review. So today is Wednesday. So if you signed a contract today, then you would have Thursday as attorney review, Friday as attorney review, and Monday as attorney review. At the end of business on Monday, you would have a binding contract. Okay, that's if you signed a contract today. If you signed a contract on Tuesday, then Wednesday, Thursday, and Friday, at the end of business on Friday, you would have a contract. Attorney review would run for Wednesday, Thursday, and Friday. Since it starts when the agent and or lawyer gets it, or only after they get it to the buyer and the seller. Technically, it's when it gets to the buyer and the seller, not when it gets to the attorney. Now, technically, I say because if the buyer or the seller has signed a attorney, a power of attorney, then the attorneys could sign off on the contract when it's been. They can start attorney review when they get the contract. But we want to think about it more. I mean, that's the way you could do it that way. But we want to think about it more that when it gets back to both parties, buyer and seller, that's when it starts. But if you sign a contract before business hours start in the morning, then it starts the same day, right? And the answer is some of the court cases have said that it does start the same day if you sign it before business hours. Okay, but we're getting beyond our pay grade. We don't want to advise people that way. The advice when somebody would ask us a question like that we would give is, you know what, talk to your attorney. That's above my pay grade. And that'll keep you out of trouble. Okay? So your job, by the way, is to let people know they need an attorney unless they choose not to use one. And the way we do that is with this form. This form lets people know that they don't have to have an attorney, but we recommend they do. And in all these paragraphs, it says over and over again, listen, you're making a mistake here if you don't hire an attorney. But this form lets buyers and sellers know they don't have to hire an attorney. Right? This is called the Opinion 26. The Opinion 26 form has to be signed in all transactions, and it lets the buyer and the seller know that they don't have to have an attorney, but we recommend they do. So if you hire an attorney, they can kill the contract within 3 days. You do not have to hire an attorney. Opinion 26 is a document that informs all the sides about what's going on. As real estate agents, we can only fill in the blanks and approve contracts. Real estate agents can only write contracts, can only fill in the blanks on 1 to 4 family homes, single lots, condos, and co-ops. But we can sell anything. If we're going to sell a 5-family home, we can, but we do it with a letter of intent. And the letter of intent usually will say, Mr. Smith and Mr. Jones agree that Mr. Smith will buy the property, and he's going to pay $400,000 for it, and he's going to have 30 days due diligence to do inspections, and he's going to finance it with a 80% loan-to-value loan. And the most important thing is he's going to pay Bruce a commission. Right? That's the most important thing to me, that he's going to make sure he's going to pay me my commission. And the buyer and the seller sign it, this letter of intent, but this letter of intent is not binding. It's just a letter that expresses the intent of the buyer and the seller to make this particular deal. And then this particular deal, the contract is drawn up by their attorneys. And since the contract is going to be drawn up by their attorneys, our letter of intent does not have to have attorney review language in it. And their contracts do not have to have attorney review language in it because they're prepared and reviewed by attorneys. And what's the difference here? When you go to a 5-family home and your attorney prepares the contract, instead of charging you $1,000, he's going to charge you $5,000. Okay? Or more. If the attorney did a very poor job after review, how to deal with this kind of unprofessional attorney? Well, again, if the 3 days isn't up, you can hire another attorney. Suing attorneys is very difficult. The reason most attorneys are in people's opinions, poor is because they are not communicating enough with their attorney. So you need to communicate with your attorney before you start to use him, because then you can tell how good his communication skills are. If your attorney says you're out of attorney review and the 3 days has passed, whatever you signed, you are stuck with. Whatever you signed, you are stuck with and obligated to go through with, or you're subject to those remedies for breach that we talked about a few minutes ago. All right, so let's do a couple questions. And in this particular case, I'm not going to rush you through this tonight. So you guys read them and you answer them. So until I see a bunch of answers coming in, I'm not going to go to the next question. But I will tell you that we talked earlier about contingencies. When you sign a contract, it's a bilateral contract. And in the contract, there are some contingencies. Typically, you have a contingency for getting a mortgage. If the buyer can't get a mortgage, the deal could be off. You have a contingency for a home inspection. If you find a home inspection item and the seller won't fix it, the buyer can get out of a contract. Typically, you have a contingency for what kind of a deed you're going to get and what would be the cost of getting the deed into the correct condition. And so usually they'll say the seller reserves the right to cancel the contract in the event the cost for him to perfect the deed is more than $1,000. It's a kind of a typical thing. That would give the seller a way to get out of the contract if he had some unknown liens that he didn't know about that were going to make it so he wouldn't really want to sell the property. So again, you have all kinds of contingencies in the contract. Sometimes in a contract, you have a contingency that the buyer doesn't have to buy unless he sells the house he lives in. All right, again, just all different kinds of contingencies. So let's get some answers on number 1. And this is a strategy question. And the answer is an escape clause. It's a strategy question. So let's go over and explain what it means. So you're going to accept a contract from a buyer, and it's contingent upon the buyer selling his house, so he has enough money to buy yours. But you don't want to be tied up on that deal forever. So you want to try to have, the seller would want to have an escape clause. So in the event, let's say a month went by, and the buyer still hadn't sold their house, and now another offer came in on the house, you would want to be able to accept that other offer with an escape clause. So an escape clause is kind of the opposite of a contingency clause by a buyer. An escape clause is the way the seller can get out of the deal. All right, number 2, to be legally valid, a contract of sale must be. So which of these 4 things is one of the essential elements of a contract? And again, it must be negotiated between competent parties. It's D. So a lot of D answers on there. You guys are getting good. A rescission of a contract. Remember, we said the rescission was the least desirable option. A rescission is when Winston Churchill got run over. He said, forget about it. He should have sued for damages. So a rescission of a contract is what? Good answers, guys. It's a D. It's a return to the status quo. A rescission is a return to the status quo. And why is it the least desirable option? It's the least desirable option because the injured party isn't getting any money. Now, number 4 comes up in a couple of different uses. And that is, a rescission is a what? I'm sorry, a substitution for a new contract for an existing one. A substitution for a new contract for an existing one. So the answers here. C. Good job, guys. It's C. It's a novation. And when might we use a novation? Well, when we're talking about assuming a mortgage, right? And you are the original borrower, and you are going to let the new borrower assume your mortgage. As the original borrower, you signed a mortgage and a note and gave it to the bank. And when he's assuming it, the new borrower is going to sign a mortgage and a note. And if you want to be cut loose in the chain of responsibility from the lender, and you want them to release your mortgage, you would do that with a novation. You would have them release your mortgage with a novation, and that cuts you off from the responsibility of the loan. Another time it's used is you have Jane Smith buying a house, and I have it going on now, and Jane Smith couldn't qualify for her loan, and so now we wanted to add her father, John Smith, to the contract. Well, we can't just put John Smith on the contract. We have to do it with a novation. We have to have another agreement where both parties agree to put John Smith on the contract. So that is also a novation. Number 5, a seller refused to pay a commission to the broker even though there was a valid listing agreement and the broker procured a buyer for the property. What can the broker do? And with the broker, let's see, we got some answers here. And the answer, got some correct answers here. Good job. Is sue the seller in court. Sue the seller for the commission. In order to sue the seller for the commission, we have to have been working under the written authorization of the seller or had an oral contract that had the predominance of evidence. And we had to be licensed at all times during the transaction. So we can't file a lien on the property, and we can't obtain an injunction to stop it until the commission is paid. And that's because that would harm the other side, right? It would harm the buyer because they wouldn't be able to buy their house. And typically the buyer doesn't pay the commission, so we don't collect the commission from the buyer. So that's a bad answer there. And as you guys are getting more and more information, and this stuff is sinking into your heads, I can tell because the type of questions you are asking is indicating that you're getting more and more aware of everything that goes on. That's really good. And I appreciate when that's supposed to happen. All right, a couple more questions. Same thing, we'll go slow. All right, a void contract. What do we got here? Void contract is B. That's some good answers here. It's one that's not legally enforceable. So a void contract is B, not legally enforceable. C, the legal proceeding or legal action brought by either the buyer or the seller under a purchase contract to enforce the terms of the contract. So if you're going to go to court and you're going to make the other side do what they promised to do, what is that called? And we're seeing some incorrect answers and some correct answers, but that's specific performance. That's the last remedy that's available for breach of contract by either side. That's when you're going to court to force the other side to do what they say. If upon the receipt of an offer to purchase their property under certain conditions, the seller make a counteroffer, what happens to the purchaser's original offer? Remember, a counteroffer means the seller said, no, I won't take $100,000, but I will take $105,000. What happened to the original offer by the buyer? You guys all got that right? It's D. They are relieved of their original offer. They are relieved of their original offer. Number 9, if a buyer defaulted some time ago on a written contract to purchase a seller's real estate, the seller can sue for damages only if they are prohibited from doing so under, and again, I'll tell you this one, it's the Statute of Limitations. What's the limit for the length of time that we can sue? And number 10, an option contract. Let's get some answers on number 10. Option contract. We've got some correct answers here again. Let's see what we got here. Good, everybody's got that one correct. An option contract, the purpose of it is to keep open an offer for a specified time, the option period. And the buyer buys it at his option. If he chooses not to buy it, the seller can't force him to buy it. Okay, so it's not A because it doesn't require the optionee to complete the purchase. That's nonsense. It doesn't give the optionee an easement. It has nothing to do with it. And it makes the seller liable for a commission. Not necessarily, but it does keep open an offer for a specified time. Specific performance is the most severe remedy for breach of contract. So specific performance, somebody, the seller doesn't show up at closing to give you the deed. You're the buyer. And the seller doesn't show up at closing to give you the deed. The most severe remedy is you go to the court, and the court will force the seller to transfer the ownership of the real property. Of course, the seller will make you give the purchase price to the seller. Now, that's different from just suing you. And again, it shows how important real property is to personal property. Because if you just sue, if the seller doesn't show up at closing, you're going to sue the seller and for compensatory damages, so you're going to get money. So that's like just a normal thing in court, to sue somebody for the damages they caused you. The most severe remedy, because real estate is more important than money, and again, real estate is considered to be more significant than money, the most severe remedy is to go to the court, and the court will take the real estate away from the seller and give it to the buyer. But that is a very severe remedy, because real estate is considered so much more important than personal property, than money. Okay, I hope that did it. No idea what you're talking about. Specific performance is not a type of injunction. Specific performance is where the court forces the seller. So the court goes into the county clerk's office, gets the deed. It's not really what happens, but just figuratively, gets the deed and gives the deed to the buyer. That's specific performance. If you're just suing for damages, the court orders the seller to pay the buyer money for the losses the buyer suffered by the seller not showing up at closing. So that's not as severe of a remedy as the court taking the property, taking the ownership of the property and giving it to the buyer. Okay? Any deeper of an explanation than that, we got to get an attorney on it. Let's see, question number 7. But you're asking them to enforce. That's what makes it specific performance. You're asking them to enforce the terms of the contract. If you're going to sue them for breaching the contract, that would be damages, and you might get an injunction. Or you might get them to stop selling to someone else. And again, we are not lawyers, and I am not giving you the legal definition of what you can do if you were in court. Instead, I'm giving you what the Real Estate Commission expects you to learn in order to pass the test. So I'm going to warn you, do not overthink these questions to the next deepest level. Okay? There are people who have problems with the test by either thinking of examples of things that they've seen happen or overthinking it to the next level. If they're situational thinkers, or if they're trying to argue a point to the nth degree, sometimes it's a little bit more difficult. Not that you're not correct, it's just that it's very difficult for real estate agents to be attorneys. So somebody's asking for these questions. These questions are actually inside that 210 question set of questions I sent everybody. I will send it again tonight after class to everybody, but we've already sent it once. Doesn't take me any effort or cost me anything to send it again, but you've already gotten the 210 questions and the answers, and I'll send them again. And of course, new people haven't gotten the questions yet, so I will send them to everybody again today. Which brings us to chapter 10. This is the chapter that will make your head spin. So where you're going to find novation in the book is in the chapter on mortgages and financing, and you're going to find novation when they talk about assumption of a mortgage in the chapter on mortgages and financing. All right, chapter 10, agency. The definition of an agency is the legal relationship between two parties who agree that one party, who is the agent, will act on behalf of the other party, who is the principal, subject to the principal's direction and control. I did have one more question I want to answer here. Yeah, I've got some stuff, but I don't think you need to do that much homework. I think you can get by with just what we're learning here, but I do have some other stuff I'll send out. Somebody asked if I have other readings. And I've got all kinds of textbooks from other sources. I can copy pages and send them to you, but really everything we need is in this book. And again, we are not becoming lawyers. We are becoming real estate agents. And I do have a math study guide I'll send you also. So again, I know math is a little more difficult. I do want to tell you that if you are going to do math, and I'll send you the math study guide, you have to suffer the pain. You have to struggle with the questions. There is no way to learn math without struggling with the questions. So I'll send it to you, but don't just read them. You actually have to feel the pain. All right, so agency is a legal relationship between two parties who agree that one party, the agent, will act on behalf of the other party, the principal, This has nothing to do with real estate right now. We are not talking about being a real estate agent. We're talking about being an agent. Okay? And who are agents? People who represent other parties. So, Scott Boris is an agent. Jay-Z is an agent. We have travel agents. We have purchasing agents. Those are all people who are empowered by their clients to negotiate on their behalf. Definitions. A principal is the person who appoints another to act on his behalf. So, in this picture here, who is the principal? In this picture here, who is the principal? Who is appointing somebody to act on their behalf? And this is the person they're acting on their behalf. This is the agent. So the principal is the athlete. He's empowering his sports agent to act on his behalf. Simple calculators allowed to be used on a test. No phones, no programmable calculators. The test itself has a calculator built in. So just like on your computer, there's a calculator built in. It has a calculator similar to that. So again, in this particular instance, the person who is the principal is the one who's being represented, and that's Mr. Lewis, and this is his agent. Okay. An agent is the person who's authorized by another, the principal, to act on his behalf. So we go back to that question again. The agent, what is he being empowered to do? He's negotiating contracts, he's negotiating endorsement deals, he's negotiating everything on behalf of Mr. Lewis. So he is the agent, Mr. Lewis is the client, Mr. Lewis is the principal. Client and principal are synonyms. Client and principal are synonyms. Who is a sub-agent? A sub-agent is somebody who's authorized to act on behalf of an agent. So let's go back to this one again. Now, this is a multi-million-dollar sports agent. He probably has a bunch of people who work for him. The people who work for him are sub-agents. The people who work for him are sub-agents. They are working under him, underneath his agency relationship, and they still owe a fiduciary duty to Mr. Lewis. Okay? In my office, I am the agent. The broker is the agent. In my office, I am the agent. And everybody who is in my office, all 20 agents, they are sub-agents of me. They are working underneath my agent authority. They are sub-agents of me. A general agent is one who has a broad range of responsibility over a long period of time. For instance, a property manager who's managing a large apartment complex is a general agent. They have a broad range of responsibility over a long period of time. The next thing is a special agent. Special agent is someone who acts with limited authority and has one job to do. When a seller says, sell my house, you're becoming a special agent of that seller. When a buyer says, help me find a house to buy, you're becoming a special agent of that buyer. What is your responsibility? Find them a house to buy. If you're a seller's agent, what's your responsibility? Find them a buyer to buy their house. And then a customer is someone you work, someone that you work with, and you do not owe them an agency duty, you only owe them honesty. So someone who is a customer is not a client. Someone who is a customer is not a client. They are not a client. And the only thing you owe a customer is honesty. And that means, what do you owe a client? What is it you owe a client? You owe a client old car, obedience, loyalty, disclosure, confidentiality, accountability, and reasonable care and diligence. These duties, they all sum up together, old car, to be what you owe a client. And these are called your fiduciary duties. Fiduciary comes from the Latin word fidelis, which means faithful. These are your duties as an agent to be faithful to your client. You owe your client old car, obedience, loyalty, disclosure, confidentiality, accountability, and reasonable care and diligence. What do you owe your customer? What do you owe your customer? You owe your customer only honesty. All you owe your customer is honesty. What do you owe your client? You owe your client old car. Listing agent is a special agent. He owes the seller old car. A buyer's agent is a special agent for the buyer. They owe the buyer old car. A property manager is a general agent for the apartment complex. He owes the owners of the apartment complex old car. What does the property manager owe the people who walk in who want to rent the apartment? What does that property manager owe these guys who want to rent the apartment? He owes them only honesty, because they are customers, they are not clients. So we've got a question here. This is a really questionable chapter. Good job, you guys are getting it now. How do we create this agency relationship? This is very important. How do we create this? And what this agency relationship is about when we're talking about real estate is we're going to talk about people, and people never have a real estate license when we're talking about them right now. Everyone who has a real estate license, we're going to call a licensee. People are these two-legged creatures that don't have real estate licenses. Okay? So when a licensee comes in contact with that rare people person, we have the opportunity to create an agency relationship. The best way to do it is with an express agreement. We talked about express contracts. That's everything is in writing. And what both parties' responsibilities and rewards are is going to be written down by an express agreement, like a listing agreement. When a person wants to appoint a licensee as a seller's agent, a listing agreement does it. If a person wants to appoint a licensee as a buyer-broker, a buyer-broker agreement does it. But now we've got a problem, because we can also create these relationships by inference, and they have a gratuitous implication. And what that means, and I'm going to draw a light bulb over the head of this person. This is a light bulb giving off light. If the light bulb goes off in somebody's head and they think that you are their agent, then you are indeed obligated to behave as if you are their agent. And that means you owe them old car. You may not intend to represent them as their agent. You may intend to work with them and keep them being a customer where you only owe them honesty. And the gratuitous implication means you don't even have to get paid to create this. It's just if that light bulb goes off in their head and they think you are going to represent them as a client and they are your agent, then that's the way you have to behave. And you don't necessarily want that to ever fall to chance. So how do we keep people, those two-legged creatures that do not have a real estate license, how do we keep them from getting the wrong idea? You have to kiss them. You have to kiss them. And what kiss them means is you have to give them a consumer information statement. So you have to give them a consumer information statement. A consumer information statement. And that consumer information statement spells out the type of relationship that you are going to have with that person. You can be a seller's agent, which means the seller is your client. Or you could be a buyer's agent, which means the buyer is your client. Or you could be a disclosed dual agent, which means both the buyer and seller are your clients. But in order to have a disclosed dual agency, you have to have informed consent to dual agency in writing. In order to have a disclosed dual agency, you have to have an informed consent to dual agency in writing. And then you could also be a transaction broker. A transaction broker means both the buyer and the seller are your customers. Nobody is your client. None of this has anything to do with who gets paid or who is the procuring cause. All of this has to do with how that two-legged creature who does not have a real estate license can expect you to act. Are you going to act as if you are their agent? Are you going to owe them a fiduciary duty of old car? Or are you going to act as if you are not their agent and they are just a customer to you, in which case you would only owe them honesty? Okay? Now, there is one last really weird relationship you can have, and the only company I know that has this relationship is Charles Smith. And that relationship is you are going to be a seller's agent on all properties that you have listed in your office, and you are going to be a transaction broker for everything else. The seller's agent on all properties I have listed in my office, and a transaction broker on everything else. And the only one who I know who works that way is Charles Smith. And that means, let's erase all this, that means if you go into Charles Smith's office, and here's a house for sale in Century 21 Charles Smith, they are always acting as a seller's agent and transaction broker, seller's agent on properties they have listed, and a transaction broker on all others. So if you are a two-legged person that's not possessed of a real estate license and you go to Charles Smith, you are always going to be a customer as a buyer. You can never be a client as a buyer, because if they have a property listed, they're telling you they're a seller's agent, which means the seller is their client and you are their customer. Now, you go to Charles Smith to see one of the listings they have, they're telling you they're a seller's agent, and that means that you are a customer. And now you say, well, I don't like that house that Charles Smith has listed. I want to go see the house that Bruce at Remax has listed. And a Charles Smith agent takes you to see my listing. They are still going to be treating that buyer as a transaction broker, which means no fiduciary duty to that buyer. So that's the weird relationship that the only office I know who works that way is Charles Smith. And again, we can be a seller's agent, the seller is our client. We can be a buyer's agent, the buyer is our client. We can be a disclosed dual agent. Both the buyer and the seller are our clients, but we have to have an informed consent to dual agency in writing in order to have that. We can be a transaction broker, which means no one is our client. Both are just customers. And we can be a seller's agent for properties we have listed in our office, and a transaction broker on all others, like Charles Smith is. Those are the forms of relationships that we can have. And how do we decide which ones we're going to be? Well, whoever that two-legged person is that does not have a real estate license, however they want to be treated, that's how they have to be treated. And if we can't deal with that, if somebody comes into Charles Smith's office as a buyer and they say, I want you to be a buyer's agent for me, Charles Smith's office has to say, I cannot represent you that way, because I am a seller's agent on all properties we have listed and a transaction broker on all others. I cannot be a buyer's agent for you. How do we let people know what our relationship is? We kiss them. What does that mean? We have to give them a consumer information statement that declares our relationship. When do we have to declare that relationship? At our first meeting with people, or if they call us on the phone before our second phone call. Now, somebody asked, and it's a really good question, it means you're starting to get it, why does Charles Smith work that way? Because Charles Smith, 95% of their business comes from two sources, and it's banks, and then it's also properties that they own. Dennis Kessler, Todd Kessler, Mitch Shannon, all buy properties, fix them up and sell them. And when they're buying those properties and fixing them up and selling them so that they have an ownership interest, they can never extinguish their agency relationship to themselves, which means they can never treat you as a buyer as anything but a customer, because either the banks are insisting on seller's agency, or all the other properties are ones they own and they can't extinguish the relationship to themselves. Now, some of the properties they might have are, from just normal sellers, but they're still going to have that same relationship. And if you're a seller and Charles Smith says to you, we're going to represent you as a seller's agent, so we have your best interest all the time. We're never going to work for the buyer's best interest. If you're a seller, you might say, that's a great idea. Let's go with it. Do transaction brokers get any commission? That's a good question. When you put a listing in the computer, you have to say how much you're going to compensate. You have to say how much you're going to compensate a buyer's agent. And typically, on a 5% listing, you're going to give a buyer's agent 2.5%. And then you also have to say how much you're going to give a transaction broker. Some people give zeros to transaction brokers. They don't compensate them. Some only give 1%. Some give the full 2.5%. Everyone is different. Where do you see this? You see it on the MLS information when you look at the agent's version of the MLS. How does the agent know what the compensation is going to be? On the listing agreement. There are places that you fill that information in. Right? This stuff is extremely confusing, and I know that. And any real estate agent that you speak to will get it wrong because they heard it once and then they never thought about it again. But we're going to try to get it all right on the test. All right, so relationship between the broker and the salespeople. So in a relationship between the broker and the salespeople, again, if this is between the broker and the salespeople, the broker is the principal and salespeople are sub-agents of the broker. Again, if you're an agent, if you are an agent of somebody, that means somebody is your client, you owe them old car. And this is such a cute thing, this old car, that it's on the test always. Obedience, loyalty, disclosure, confidentiality, accountability, and reasonable care and diligence. You have to obey all legal orders from your client. I had a client today who said he doesn't want any African Americans renting his property. And I said, well, then I can't work for you because that's an illegal order. Loyalty is you have to be loyal to your client above yourself. So if your client says, I want to see that house, and you look and see that the agent who's selling it is only offering 1%, and you say, geez, I don't work for 1%. Well, you can't say that because you're not supposed to do what's best for you. You're supposed to do what's best for your client. D is disclosure. Anything that you find out, you have to disclose to your client. So if you're a seller's agent and some other agent comes into your office and says, I'm going to make an offer on the property and I'm going to offer $100,000. But if they don't take the $100,000, I'll do $105,000. Well, your duty of disclosure is to tell the seller they're going to offer you $105,000 if you have an obligation to disclose to the seller what you know. C is for confidentiality. I've had listings in the past where the sellers are divorcing. I'm not allowed to tell people that they're divorcing. So if somebody calls me up and says, why are your sellers selling? I have to say they want to sell. I can't say they're divorcing because I have to maintain confidentiality. Accountability means that I have to be responsible for all of the monies people might give me, and I have to give them a reporting of where their money is every 90 days. I also have to be accountable for damages that might happen. One of my friends had an agent damage the key and the lock in her listing, and the agent is ultimately responsible for that. And she had to pay a couple $100 to fix it. So that's because you have an accountability and you have an obligation of reasonable care and diligence. Reasonably, if you think the lock is sticking, you should be a little proactive on it potentially and maybe squirt some WD-40 in it. Typically, that'll make them really loose and work really well. But again, those are your obligations as an agent. Your old car: obedience, loyalty, disclosure, confidentiality, accountability, and reasonable care and diligence. You have duties to third parties. Again, if somebody is not your client, then it's a third party. You owe them honesty. You have to disclose material defects. So a house today that I have under contract had a fire. Now, I just found out today it had a fire. Whoever was in it before covered it all up. You can't see it, but I found out there was a fire today. I have to disclose, even though you can't see it, I have to disclose that now to all parties. I have to disclose observations that a reasonable person would make. Now, I couldn't see the fire because they covered it up, so it's not a reasonable person thing would see, but I now found out that it has a material defect, and actually a hidden defect like that is called a latent defect. I have to disclose that to all parties. I have an obligation to let people know about what the zoning is. Off-site conditions has to do if I know that there is a dump nearby, or if the property was built on a dump and that would affect the value of the house, I have to let them know. I have to let them know if it was a house built before 1978, if it has lead, if it has oil tanks. And if I'm working for a buyer, I have to let them know that the seller has the ability to close. Another thing that we have to consider all the time is we have an obligation to disclose certain facts through the buying side of the transaction, and we are subject to a triple damages in the Consumer Fraud Act if somebody does a fraudulent representation of the condition of their house. And one of the ways that we can protect ourselves from triple damages and only be able to be sued for actual damages is we have a seller fill out a property condition report. This property condition report is a very specific format. We can't change the questions. We cannot help the seller fill it out. Some of the questions the seller could answer, I don't know. And as long as the seller fills it out honestly, they are exempt from the triple damages aspect of the Consumer Fraud Act. That's a big deal. Here's what it looks like. There's actually about 5 pages of it. And you can see the questions, you could answer yes on the questions, or you could answer, geez, I don't know. Maybe you don't know. Maybe you inherited the house. You don't know. You could answer, I don't know. So this is a bunch of pages. You cannot, as a real estate agent, help the seller fill this out. The seller fills it out. You sign it. The seller signs it. The buyer signs it. And the buyer's real estate agent signs it. So the seller's agent, the seller, the buyer's agent, and the buyer all sign it. And when they do that, and they honestly answer the questions, it protects everybody from the Consumer Fraud Act. You have to make a reasonable and diligent inquiry about a property or a buyer. It's part of your job. Does the buyer have enough money to close? Does the seller have enough money to close? Does the seller have things that are done without permits? You need to make a reasonable and diligent inquiry about a property or a buyer. It's part of your responsibilities as a real estate salesperson. And again, on the consumer information statement, when do we have to kiss people? Well, this was on D-Day, this was on Gone with the Wind, this was on The Godfather. Not D-Day, this was on Victory in Europe Day. This is when this kiss happened in Times Square. But we have to kiss people. We have to give them a consumer information statement. And the consumer information statement states our relationship. We can be a seller's agent. We can be a buyer's agent. We can be a seller's agent with informed consent to dual agency. We can be a buyer's agent with informed consent to dual agency. That means that both buyer and seller are our clients. Both buyer and seller are our clients. We can be a transaction broker. That means nobody is our client. Both are just customers. And we can be Charles Smith, which is a seller's agent on properties that this firm has listed, and a transaction broker on all others. Those are the different ways we can work with or for people. With or for. How do we let them know? We kiss them. We give them a consumer information statement. Now, if you've created an agency relationship, how do you terminate it? Because we don't want to be obligated to somebody forever. So we can terminate it by acts of the party. That means we both decided we want to end the relationship, or the client fires us, or in the case of the guy who said he doesn't want to sell, he doesn't want to rent to African Americans, renunciation, where I say, listen, that's an illegal act. I'm not going to be your agent anymore. These are all ways that we can terminate the agency relationship. The best way to terminate an agency relationship is accomplishment of the objective. Once a house is sold, then my agency relationship is over. We can also terminate it by expiration. The listing agreement has to have a time limit on it. The buyer-broker agreement has to have a time limit on it. A property manager's agreement has to have a period that it's good for. When those periods are over, then our relationship is over, and we no longer have it and we have a termination of the relationship. Also, operation of law, death of either the client or the agent terminates it. Legal incapacity of the agent or the client terminates it. And operation of law, such as foreclosure will terminate the agency relationship. Those are ways we can terminate it. So we got a question here. Buyer will not sign it on the first meeting. That's exactly right. Your duty is to present it. And if you present it, and very often they don't sign it. Nancy, that's exactly right. Your duty is to present it. And if they don't sign it, you should make a record, a note that you presented. Now you know that you're going to have that consumer information statement signed when they fill out a contract also. And on the contract itself, it kind of goes over again what the relationship is. So a second time. And on the opinion 26, a third time, it goes over what the relationship is. So in order to have a full contract set, you're going to need the consumer information statement, the opinion 26, and on the contract itself, you're going to check off the boxes about what the relationship is. We also have to think about an agency coupled with an interest. That means if you own a house and you're going to list it in your office and sell it, you can only be a seller's agent. So an agency coupled with an interest, when the agent has an interest, it must be disclosed. And you'll see this on listings. On the listing, it will say the owner is a licensed real estate agent. That means they're disclosing to you that the listing agent owns the property. And if he owns the property or she owns the property, then they can only be a seller's agent because they can never extinguish their agency relationship to themselves. All right, now the next thing is power of attorney. This is not being a real estate agent. Power of attorney is when you give somebody the ability to sign a document and their signature obligates you to the contract. Their signature obligates you to the contract. When a person gives someone else the ability to sign a document and legally bind another. So 2 years ago, I sold the most expensive house in East Brunswick, and Mr. Wang, very nice gentleman, was in China. Actually, I visited him in China. He put me up for a week. He drove me around in a chauffeur-driven Rolls Royce for a week, myself and my family. We visited Shanghai. We visited Beijing. We visited Suzhou. We had a really great time. He was a really nice guy. Didn't speak any English at all, and he was in China. So how did he buy this house in East Brunswick? Well, he had to give Ray Wang power of attorney. So Mr. Wang gave Ray Wang the ability to sign contracts on his behalf, and then it would obligate Mr. Wang to the contract. So Ray Wang was his agent, and he had power of attorney, not real estate agent. Ray Wang does not have a real estate license. He just was the agent for Mr. Wang. He could sign a contract on his behalf, and it would obligate Mr. Wang. Now, again, because real estate is considered more significant than personal property, in order to have a power of attorney to sign real estate related things like contracts or deeds, you have to have a special power of attorney in writing in order to have real estate related activity signatures. If you're just going to have a general power of attorney, and you're going to be able to sign checks to pay his utility bills, then you don't need to have a special power of attorney. You have a general power of attorney. And any time that we were signing a contract for Mr. Wang would sign the contract as Ray Wang as attorney in fact for Quinn Wang. So that means instead of seeing a signature that said Quinn Wang, you would see it Ray Wang as attorney in fact for Quinn Wang. And because we had that special power of attorney created and we had it recorded, it would give the ability for that signature to count the same thing as if Mr. Wang had signed the contract. Okay, so that's power of attorney. And they did that with a special power of attorney in writing. And again, it should be notarized and recorded, because that would make the title insurance company happy that it was a valid special power of attorney. General power of attorney is for things like signing checks. You know, your mother goes into a nursing home, she gives you general power of attorney to pay her utility bills out of her checkbook. That's a general power of attorney. That is not real estate. For real estate related matters, you need a special power of attorney in writing. How do we terminate these power of attorneys? So if Mr. Wang dies or Mr. Wang dies, it terminates the power of attorney. Mr. Wang can take it back. Hey, you're signing crummy contracts. I'm not giving you the authority anymore. He can revoke it. There can be a time limit. Mr. Wang only has a year to sign contracts for Mr. Wang. There can be renunciation. Renunciation is Mr. Wang can say, you're not paying me to do all this stuff and look at all these houses. Therefore, I'm not going to do it anymore. And the best way, because it's a special power of attorney would say, I'm giving you permission to sign contracts for that house in East Brunswick. As soon as you close on that house, accomplishment of the objective terminates the power of attorney. We see these a lot in real estate because people aren't always nearby. They're not always in New Jersey. Sometimes they're in the hospital. Sometimes they're in China. Again, power of attorney becomes very useful. Now, one of the last things we want to talk about tonight, because if you talk to a regular real estate agent who has their license, all this stuff is confused in their heads because all they think about is money. They don't think about representing, some people like Nancy, you think about representing your client. But some people don't think about representing their clients. And Sue, you think about representing your clients. Some people don't think about representing their clients. But you should. Most real estate agents think about just the money. So what determines who gets paid the commission in a real estate transaction? What determines who gets paid the commission is who is the procuring cause. And the debt, and this doesn't say whether you're somebody is your client or your customer. This has no relationship to whether they're clients or customers. This has a relationship to who is the procuring cause. Which salesperson is the procuring cause, which is the proximate, that means the nearest cause, originating a series of events which, without break in their continuity, result in the accomplishment of the objective. And this kind of stuff is always coming up as an issue. So I have an open house, and I'm at the open house, and I get people coming in, but it's Sunday, and I'm missing all my football games, so I'm not happy. And a buyer walks into my open house, and I say, hi, I'm Bruce Parker. I'm a seller's agent for the bank, and would you like to see the house? I'm going to be representing you as a seller's agent, which means the seller is my client. And you, Mr. Buyer, are a customer. And he says, that's okay, I just want to see the house. So he comes in the house, he sees the house, he walks around, he looks, he asks me a couple questions, I answer them. He goes home and he sees his cousin who has a real estate license. And his cousin writes a contract offer and sends it to me. Now the question is his cousin the procuring cause? Is his cousin due the buy side of the commission? Or am I due the buy side of the commission? Because I am the one who originated the series of events. Well, this is a question that comes up all the time. And it's not simple for me to answer who is the procuring cause. Instead, we have a mechanism for that in most cases. And that's one of the reasons that you join the realtors. Because the realtors has a mediation and arbitration a mechanism for deciding who gets the commission, who was the procuring cause. And that method, when you join the realtors, you promise to be bound by their arbitration. So whatever their arbitration decision is, you're going to be bound by it. And in 30 years, I've gone to 3 of these hearings. And recently I had one in Highland Park, which we won. So we got the buy side of the commission. Exactly the same situation. One of my agents was doing an open house. A buyer went in, and an agent from North Jersey who had never even been in the house sends a contract in. So who's going to get the buy side of the commission? Well, my agent won, and he got the buy side of the commission. How does that get decided? Well, if you go to arbitration, and here's an arbitration worksheet, they're going to ask you questions. And each of these things, here's the answer. Does it favor the complainant, the person bringing the charge, or the person answering the charge, or neither? And then notes. And then they kind of, go down the chart here and they ask questions. And the members of the board, usually it's 3 to 5 people, are making decisions on this stuff. And at the end, they make a subjective decision as to who's going to get the commission. And you are bound by that decision. You are bound by that decision. And you can file an appeal if you don't like it. Oftentimes, it's a much better idea to negotiate with the other agent and come to a compromise. So just remember that when the time comes. So we've got a question here. Can you quickly explain dual agency and consumer information, please? All right, I'll do that in just a second. And Nancy says she's been through arbitration and mediations twice. Keep good records. She's absolutely right. Remember that parole evidence rule? Things that are in writing take priority over things that are oral. You're going to have all your notes down. You want to keep all your text messages and all your emails so you can prove, a timeline, and you can prove who was the procuring cause. So Nancy, I'm glad you won both times. So let's go over again real quick, dual agency and the consumer information statement. See, I'm trying to find a blank screen here, so it's a little easier here. Let's see if this will actually help. So disclosed dual agency means, here's my office, and I am the broker, and everybody who works for me is a sub-agent of me, not a salesperson, not a sales agent, but a sub-agent. And here is a person who wants to sell a house, and I agree to be the listing agent with disclosed dual agency if the opportunity arises for this seller. And I am representing this seller personally because I like him. And now this person in my office has a buyer, and this person is representing this buyer as a buyer's agent. This person is representing him as a buyer's agent. Sorry about that. I'm getting tired. I'm sorry about the scribbling. And I am representing this person as a seller's agent. Now, where that becomes problematic is this seller's house is here. And now everybody who is in my office, however they represent somebody, everybody else in the office represents them the same way. So if this particular salesperson is representing him as a buyer's agent, everybody in my office has to represent that person as a buyer's agent. I'm the broker. If I'm representing this particular person as a seller's agent, then everybody else in my office has to represent him as a seller's agent. So now what happens if this buyer, who's being represented as a buyer's agent, wants to see this house that I'm representing the seller as a seller's agent? Well, that creates disclosed dual agency. So in order for that to happen, we have to have the seller sign a seller's consent to inform dual agency in writing. An informed dual agency means I had to inform him what it means, and the buyer is going to sign a buyer's informed consent to disclose dual agency. And if we have both of those, and then in this case, that buyer would be allowed to see the listing, even though I'm representing the seller as a seller's agent only. So again, this is why any salesperson you ask will not remember this, because it's very, very complicated. Now let's see what the question is here. And then we'll... Yes, the question is, should we keep a record of verbal conversations? I would. And there's really less and less verbal conversations now and more texts. So I think you can go to your cell phone provider or your app or Apple in the Apple Store, download a transcript of all your texts, even if you erase them. I think you can get that. But real estate agents never erase their text; keep them forever, just in case you have to prove something. So let's go back again. Let's go back again to a couple other things here. The commission gets dispersed at the closing by the closing agent. The closing agent does not mean salesperson. The closing agent means the person who is responsible for signing all the paperwork on the mortgage and the note, receiving all the money in from the new mortgage, and dispersing all the money. So usually that is a representative of the buyer's title insurance company, or it's the buyer's attorney. All the money flows in through the buyer's attorney. All the money flows in through the buyer's attorney, and money comes into the buyer's attorney, and then the buyer's attorney disperses the money at closing. They pay me, they pay the other agent, they pay the attorneys on both sides. They pay off the original mortgage that the seller had. They pay off his mortgage. Okay, if the seller is going to get money, they're going to write the check to the seller for his proceeds. Okay, and that happens at the closing table. Now, sometimes it doesn't actually physically happen at the closing table because sometimes the banks don't fund the mortgage quickly enough. The banks are on the West Coast mostly, and they like to have that money in their possession for as many hours as they can because they're getting interest on those hours that they have the money. So disbursement of the commission happens at the closing of title and the closing of the mortgage and the closing of escrow. There's a prohibition against dual compensation for dual representation. So in my office, I'm a broker. There's my hat. And my wife is an attorney. There's her hat. We can't represent a buyer as both the broker and the attorney because now we're working in two roles. And it's illegal. It's against real estate commission rules to have dual representation. And the reason is there needs to be a dividing line because the attorney has a different set of responsibilities to protect their client against than the real estate agent has. So there is a prohibition against compensation for dual representation. No wearing two hats in the same year. When you sign your employment agreement, remember we talked about you have commission, you have a promise to pay you within 10 days, you have a termination agreement, and you have a statement that all things that are in writing take things that are oral. You also, in your employment agreement, will have a statement that says whether you're an independent contractor or an employee. Congress passed a law that's called the Safe Harbor provision that said that real estate agents are automatically independent contractors if they have a real estate license and they are paid commission. So 90% of your pay has to be based on commissions if you want to be an independent contractor under the IRS Safe Harbor provision. And that means that when you are paid $100, $7 has to go to Social Security, $1 has to go to unemployment, and you're going to pay your employer's side of Social Security and unemployment also. So again, out of your check, it's going to come somewhere around 7 is 14, 15, 16, or 17% extra. That's not even your income taxes. Remember, when you're an employee, you pay the 7 and the 1, but your employer, which you don't see, pays the 7 and the 2 on his side. So you are an independent contractor because of the Safe Harbor provision of an act of Congress. No employment taxes will be paid by your broker as long as you have 90% of your pay based on commission. If you're an employee, and some people are, or you get paid by the hour, the week, the month, etc., then your employer is going to pay their part of the employment taxes, and you're going to pay yours. COVID made this stuff crazy because real estate agents are independent contractors, and we don't pay. We don't have employers. So up until COVID, real estate agents were not allowed to collect unemployment. But they made an exception under the original COVID laws that were written when we first wrote the original set of laws. I can't remember what it's called now, but the CARE Act, I guess maybe. When we wrote the CARE Act, we made independent contractors eligible for unemployment. So for the first time, real estate agents got unemployment. Now, so many real estate agents got unemployment. You better watch that sometime in the future, they're going to take this back and they're going to say, listen, those real estate agents were really happy to get unemployment benefits. So let's, from now on, let's make real estate agents employees. And I hope that never happens because I don't want to pay unemployment taxes, Social Security portion on the agents who work for me. But it's something that might happen sometime in the future. Next thing is there's a lot of the antitrust laws that apply to real estate and the anti-monopoly laws. Sherman Antitrust Act, the Clayton Antitrust Act, the Truth in Lending Act, all have anti-monopolistic laws in them, as does the Real Estate Settlement Procedures Act. No price fixing. That means I can't go to all the other brokers in Highland Park and say, let's all charge 6%. No boycotting other brokers because of discounts. So if one broker only charges 1%, we can't all get together and decide we're going to boycott them. No tying agreements. A tying agreement is if I buy this house, if you let me buy this house, I promise I will use you to sell it. That's a tying agreement, and that's illegal. Allocating customers by markets or by price range. I only work in $200,000 sellers. Somebody else only works in $500,000 sellers. And we agree that he'll never work with the 200 and I'll never work with the 500. That's allocating customers. And excluding brokers from membership in the MLS systems is another one. Now, recently, our friends at Bright MLS, which used to be Trend, is charging outrageous fees for Middlesex agents to join Trend or to join Bright. So we may be filing a suit against them for exactly violating antitrust laws. Next thing is all brokerages should carry errors and omissions insurance. That's a form of insurance that if you get sued for creating a mistake, that the insurance company will pay for. On errors and omissions insurance, typically you're not getting the policy, your broker is, but your broker is asking you to contribute to the overall premium. Most brokerages will charge you somewhere around $500 a year. So most brokerages charge you somewhere around $500 a year. How they charge you is up to them. All right, so a couple of quick questions, and then we're done for the night. And we're running late, so I'm sorry about that, guys. It's a lot of information tonight. Number one, a broker's fiduciary obligations do not include which of the following? And the answer to this is executing contracts on behalf of the seller. We don't sign contracts on behalf of the seller. We do disclose conflicts of interest, we do disclose material facts, and we do obey. That's all part of old car. Number two, which of the following would not terminate an agency relationship? So revocation and renunciation. I fire the agent fires the client. In mutual consent, we both agree to end it. Which one does not terminate? Reciprocity. There's actually no such thing in agency. Just a word they threw in there too. Number three, all but which of the following are fiduciaries? So a guardian has a fiduciary duty to a minor or an incompetent person. A broker has a fiduciary duty to his clients. A trustee in a bankruptcy has a fiduciary duty to the people that are claiming to be creditors. A principal, and that's the answer here, a principal is the person to whom the fiduciary duty is owed. Number four, the real estate broker's responsibility. It's old car, OLDCAR. There's no A in old car. So reasonable care, disclosure, and obedience. Which of the following would be considered a dual agency? And a dual agency is the broker acting for the buyer and the seller in the same transaction. And in order to have dual agency, you have to have an informed consent. You have to have informed consent to dual agency in writing. So you have to have the informed consent to dual agency in writing in order to do that. All right, a couple more questions and then we're done. A broker is permitted to represent both the buyer and the seller in the same transaction, and when both parties have gotten informed consent to dual agency and they've signed it. So when both parties have been informed and agreed to informed consent to dual agency. So it's D. Unless some other written agreement has been made, the broker will usually receive the sales commission when, and it's when the transaction is closed. Right? Sometimes the purchaser never takes possession. Right? If it's a rental, they never take possession. So the answer is when the transaction is closed. A real estate salesperson who is an independent contractor receives, and it's negotiated commissions on transactions. A salesperson who is employed by a broker told a prospective buyer that the house she was looking for is the best in the area. because of this, the salesperson is guilty of puffing. Now, puffing is making exaggerated claims, and it is not necessarily against the rules, but it is not a good idea, and you shouldn't do it. You're guilty of puffing, making exaggerated claims. Number 10, a broker who is the agent of the buyer should do which of the following? Should he disclose to the seller that the buyer is a minority person? No, that's illegal. Should he disclose to the seller the maximum price that the buyer will pay? No, because he's the agent of the seller. He owes the seller confidentiality. Should he present to the seller only offers that are acceptable? No. What he should be doing is he should be presenting all offers within 24 hours. And last, the correct answer is D. Since he is the representative of the buyer, he should advise the buyer if the seller's house is unrealistically priced, because he has the best interest of the buyer at heart. All right, these are tough questions, and we blew by them tonight because we're running late on time. I am going to send everybody the 210 questions tonight that these come from, so you can play with them on your own, and I'll send everybody the answer sheet. Again, it's a really good tool to work on the questions. That's about it for tonight. It's a long night. We got one check here. Okay, we got your answers. We're moving along. 1 through 4. Somebody missed the answers on. Let's go back and hit 1 through 4. One, a broker's fiduciary obligations do not include executing sales contracts. We don't sign contracts for people. Number 2, which of the following would not terminate an agency relationship? Reciprocity. Reciprocity has nothing to do with agency. Revocation is, mutual consent is, renunciation is. 3, all of the following are fiduciaries except which one? The principal. The principal is the one to whom the fiduciary duty is owed. The real estate broker's responsibility to keep the principal informed is the duty of disclosure. Real estate broker's responsibility to keep their principal informed is disclosure. And then 5 is which of the following would be considered dual agency? And it's the broker acting for both the buyer and the seller in the same transaction. All right, guys, that's it for tonight. We will see you all Tuesday, but I probably will run a bonus class before then. So just watch your emails.